motion limit, which you did remind me of yesterday, or initially say yesterday. But how long have you had this particular tape or knowledge of these particular instances? That's my first question to you. You got them in discovery, correct?
Sir,
Did you get them in discovery?
Yes, the prior.
Okay, then why are you just now, yesterday, telling me orally and not doing what you did in your motion so I could kind of take it up?
What? I did do it in my motion.
No, you filed a motion, but you could have filed this thing months ago.
Your Honor, out-of-court statements are not admissible at trial.
Okay, that's not what I asked you, okay? If you believed it was going to be an issue, you could have filed this same motion 3, 4, 5 months ago, correct?
It's not.
Yes or no?
If you want me to say yes, sure.
Okay, that's my point. That's my point about being a forewarned judge is a happy judge, okay? Because we are now taking time out, and I'm putting the jury in the back on something that you told me yesterday about, but you could have memorialized this in a motion more than 3 months ago, probably last year. And I could have taken it up, and I could have ruled on this. I don't have any problem with that, but this is an example of something. If you want to do something like this, go ahead and file the motion. You should have filed it months ago. That's what I'm annoyed with.
Okay, in Your Honor, the state...
And that's what it means to be prepared as an advocate.
Okay.
The state's giving you this, okay? You knew about this issue, right?
Perhaps the state, knowing that it's an issue, would not want to admit evidence of an individual being a prosecutor
I get it.
and a defense attorney on the same
I
time.
get it, but
so
you
perhaps it's not on me. Perhaps the state should not be.
Oh, it's on you,
okay,
and it's on them. It's on
me.
You know why? It's on you because you could have filed this thing months and months ago, and you could have also had a conversation with the state.
I have.
Okay, and are they going to use this particular information?
You'd have to ask them.
Well, that's not what I asked you. Are they going to use that particular information?
I cannot speak for the state, Your Honor.
Okay. Do you see the problem or the issue that you filing this untimely motion has caused? Yes or no?
You're not going to like my answer, so I'm just going to remain silent.
That's not being an advocate, because if you can give me a reason as to why you waited months and months, because you probably, when did the state give this interviews? The first interview or note that you were going to, about the proffer agreement with Mr.shardt Jimenez.
The proffer agreement was in the first round of discovery in July of 2022.
Okay. When was the other interviews that were made from 2015 turned over?
July 2022.
Okay. So arguably, Mr. Shardt, this could have been filed sometime in 2022 or early 2023 when we started having these particular motions. Your colleagues, you filed several motions, several preliminary issues I've had to take up. So that's what I'm telling you in terms of just having to stall the proceedings so I can go ahead and take this up.
I'm not trying to stall anything, Your Honor.
No. And I don't mean you. Listen. I don't mean you like just filing this to stall it. Okay.
Okay.
All right. But
the state has.
But you filed it. But my angst with you. I don't have any angst with you filing a motion. I don't.
Maybe you are feeling that you don't respect me because you don't know me very well.
Michael, I've known you a very long time. And the more I've gotten to know you, the less I've come to respect you.
I'm just annoyed that you didn't file it in 2023.
The state has been fully aware that their colleague, who was a gang prosecutor, was serving as a defense attorney on this case. And
okay, but that's
understand why it's my job to flag that issue. But I have flagged the issue.
Okay.
And so if I'm going to take
now you flagged the issue now on the 10th of April of 2024. Have a seat, sir.
Okay, thank you.
State, are you going to be using this recording involving, I'm going to mark Mr. Shardt's motion in limine as the next court exhibit, but are you going to really use this motion? I mean, use the proffer agreement or proffer that that was held on or about February 16th of 2016? February 16th, 2016?
Yes, and Mr. Murphy continues to go down this line of questioning, and
I'm going to tell you, that's a very ethical, problematic thing for you all.
Your Honor, and this is what I'll say. Mr. Rico Jimenez waived his conflict and decided to take a defense attorney in this case when he knew he was a prosecutor in 2016.
No, but it's you all's use of that. I think that his waiving is another separate issue, okay, which we didn't have to get into because of that particular issue. But utilizing his particular proffer that he was involved in might be a problem.
But it's a proper of the state of it's a prior inconsistent statement.
But he's a counsel that was involved in this case.
Right, but Your Honor, there's no legal basis, there's no ethical basis for this ruling. He was a state's attorney, like anyone else can get jobs and move on and do whatever they want.
I know that,
and there's a prior inconsistent statement. Whoever the state's representative is doesn't matter. The fact of the matter is it's a prior inconsistent statement.
Well, I think
it
may confuse the jury because the jury's seen Mr. Jimenez as a defense counsel for another prior accused who is now no longer in this case. So yes, there is the possibility and the probability that they are going to be confused about that.
So can we not just instruct the jury that he was previously with the state of Georgia and left and got a new job? Like what? There's a remedy for that. The state is not going to harp on the fact that Mr. Jimenez was a prosecutor then, but this is the prior inconsistent statement. He had a previous job, and like anyone else in the world, in the country, they can leave their position and go on to another case. When this case started, Mr. Jimenez knew that this proffer existed. He chose to represent a client in this case. He's no longer representing any of these individuals in the courtroom, Your Honor. So Mr. Jimenez, as a defense attorney or a prosecutor in this case, is of no consequence because he's not even present in these proceedings. His work with this case is completed, Your Honor. The sole reason why we're bringing this in has nothing to do with Mr. Jimenez. It has solely to do with the prior inconsistent statement, and the state should be able to confront this witness with any prior inconsistent statement that he plans on clearly giving during the course of his testimony in court.
You'd agree that Mr. Jimenez's, if the tape or anything would be utilized, it would have to be redacted.
I don't agree with that, Your Honor, because he does not, and a few things about the proffer, Your Honor.
But you see, here's the problem, and here's what I'm going to get on you all about. You all knew this was going to be an issue.
We did not.
And you put this in discovery.
But we did not think
one of your former colleagues who took a proffer, who then you made it as part of your discovery. So how could you know it wasn't an issue?
Because, Your Honor, we put the proffer because that's the prior consistent statement. It had nothing to do with Mr.
I know, but
we did not think this was going to be an issue.
But the employment issue may be something that the court wanted to take up.
Your Honor, but the state did not believe it to be an issue until Mr.shardt brought it to our attention yesterday. The state did not believe it to be an issue because
all right, I guess you all will be working this weekend then, because this is exactly what I told you was going to be a problem. You bring this stuff up, I got a jury sitting in the box, and you got a witness that you're probably going to have days of examination with. So let me go ahead and decide. I'm going to recess for about 10 minutes. We'll make a decision on that. Because
any other theories?
All right, you don't respect me. I accept that.
Caught in the crossfire.